Trump's motion to dismiss the superseding indictment based on the unlawful appointment and funding of Special Counsel Jack Smith is hereby granted. Oh, what does that mean? The superseding indictment is dismissed. Bye-bye, case is gone. Sorry, Jack. As of September 2023, Jack Smith has spent $12 million. And watch this. He's also dropped another $11 million in component expenses that are attributable to this investigation. That's our money. We paid for that. It's sick. Judge Alina dismisses the classified documents case. Woo, this is a good one. Excited to see it here. I want to start with just the final portion of the opinion, the order here. This is now ordered and adjudged as follows. Trump's motion to dismiss the superseding indictment based on the unlawful appointment and funding of Special Counsel Jack Smith is hereby granted. Oh, what does that mean? The superseding indictment is dismissed. Bye-bye, case is gone. Sorry, Jack. You lose. The whole case, God. Oh! The order shall not affect or weaken any of the protections for the classified information imposed in this case or any protective orders pertaining to the classified information. So all of that's still going to be under lock and key. But the clerk is directed, watch, to close this case. Oh, Jack Smith, blown out. Any scheduled hearings are canceled. Any pending motions are denied as moot. And any pending deadlines are terminated. Just like you, Jack. Done and ordered in chambers at Fort Pierce, Florida, this 15th day of July 2024. So Jack Smith is done. Trump came out, he posted this. He says, as we move forward in uniting our nation after the horrific events on Saturday, the dismissal of the lawless indictment in Florida should be just the first step, followed by the dismissal of all the witch hunts. Now, this case, as I said, will be persuasive to the January 6th hoax in Washington, but not binding, and it will really have no other relevance to any of these other state level claims because Jack Smith is only prosecuting the two federal claims. But Trump is right about this. Now, the immunity decision plus Jack Smith's unlawfulness are showing us clearly that all of these were political prosecutions. There was no basis for Jack Smith to even exist. He's not a U.S. attorney, was never appointed by the president, was never confirmed by the Senate, was illegal from the very beginning, and they prosecuted Trump anyways. Same thing with the DA Zombie case from Manhattan. Trump had immunity. Trump layered in immunity. He objected based on immunity during the trial, and he was overruled. Judge Merchan just allowed the case to go forward. And now Trump is saying, you brought in evidence of my Oval Office conversations and my team, my employees were all part of the case. They were all testifying. We had Hope Hicks, White House Communications Director. We had Madeleine Westerhout, Oval Office Operations Director, all testifying, all Oval Office immunity stuff. So Trump continues. He talks about the New York AG scam, fake claims about a woman I never met, a decades-old photo in a line with her and her husband does not count, talking about E. Jean Carroll getting Bergdorfed in a Bergdorf's, and the Georgia perfect phone call charges, which is Fannie's case. The Democrat Justice Department coordinated all of these political attacks. That's true, which are an election interference conspiracy on their own against Joe Biden's political opponent, me. Let us come together to end all weaponization of our justice system and make America great again. And so Trump was out. We had other reaction from Thomas Massie. He says, last month I questioned Attorney General Garland about the constitutionality of Jack Smith's appointment. He did not have good answers, and we remember that exchange. He says, fast forward to today, Judge Cannon just dismissed the classified documents case against Trump, citing the unconstitutionality of Jack Smith's appointment because he is illegal. And we've read basically every single motion that has been on this case, so now justice has been done. Adam Schiff is very upset about this. He says, today's precedent-shattering decision in Florida is further proof that the guardrails of our democracy are coming down. It's like, you guys are whack. You know who knocked those guardrails over? You guys, when you indicted Trump in the first place with an illegal special counsel for charges that are fake. They were his documents, and other people who've had the classified documents problems who were never the president, like Hillary, like Pence, like Senator Joe Biden, like VP Joe Biden. No charges for them. So guardrails of our democracy just means they're never-ending power. Just substitute democratic power every time you hear democracy. The guardrails of our democratic power are coming down. That's true, because your Democratic Party is now being shown for what they are. Again, a partisan judge throws out decades of precedent, but he says to reach a desired political outcome, which is hilarious because that's all they're doing. He says justice is again delayed, so it may be denied. Ben Garrison went very quickly. I don't know how he does it so quickly, but this is Jack Smith's worst nightmare. And I don't know if this is new or if he had already prognosticated this, but case dismissed. Trump comes in with pizza for everyone. What a nice guy, man. Here's one from Jonathan Turley. Says the dismissal of the classified documents case is a seismic development. No doubt. From the beginning of all these cases, I've said that the Mar-a-Lago case was the greatest threat to the former president. It is now gone. It's huge. And we were a little concerned. I think your boy here may even have said that I don't think Cannon's going to do this. Pretty sure I said that. This was a big deal. This is a big move, and it's absolutely the right decision. We've read through every single amicus brief from Ed Meese and the other individuals, and it's the right decision. Here is how MSNBC was reporting it this morning. Let's see if they're happy about this.
Breaking news on the classified documents case. Let's get right to Ken Delanian. Ken.
What's the latest, Ken?
Jose, in a remarkable development, Judge Alina Cannon in Florida has dismissed the indictment against Donald Trump in this classified documents case and his co-defendants on the grounds that the appointment of the special counsel violated the appointments clause of the Constitution. This is an issue that has been litigated in other special counsels, has never succeeded, but Judge Alina Cannon has accepted the arguments of the defense that the appointment of Jack Smith and other special counsels by inference has been improper and illegal. And I'll just read you briefly from the opinion here. She says the bottom line is this: the appointments clause is a critical constitutional restriction stemming from the separation of powers, and it gives to Congress a considered role in determining the propriety of vesting appointment power for inferior officers. The government's position, she says, effectively usurps that important legislative authority, transferring it to a head of department.
Yeah, we'll go through the whole thing. So Alina Habba also came out, says the unlawful appointment and funding of Special Counsel Jack Smith has been a critical factor of the sham documents case. This dismissal marks the first step in ending the weaponization of our justice system, restoring the rule of law, and making America great again. Yeah, Jack Smith, if they really wanted to go after Trump, they could have just appointed a special counsel who was U.S. attorney. That would have been interesting of them to do that. Now, we know that they know how to do that because they've done that before. So remember when Joe Biden ordered Merrick Garland to go after Trump, Merrick Garland came out and appointed Jack Smith to prosecute Trump. Jack Smith was not appointed by the president or confirmed by the Senate. But then when Joe Biden had his classified documents, guess what happened? Merrick Garland came out and appointed Robert Hur. Remember Robert Hur? So Robert Hur, as we know, is an actual United States attorney for the District of Maryland. Oh, isn't that interesting? So Robert Hur was appointed by the president, was confirmed by the Senate. So Jack Smith, who was not appropriate. And as we know, as we can see here, the DOJ knows how to select U.S. attorneys to be special counsels. So it's nothing out of the ordinary. They know how to do it. They just chose to pick Jack Smith because he is their hatchet man, and they're very excited about him doing their bidding. It worked out well for him until it didn't. Now they have lost. And so let's take a look at the opinion itself that we're going to go through here to see how this all works. In the classified documents case, Judge Alina Cannon presiding, now ordering and granting Donald Trump's motion to dismiss the superseding indictment based on the appointments clause violation. Here's what Cannon says. All right, former President Trump's motion to dismiss this whole case because Jack's illegal is hereby granted. The indictment is dismissed because Jack Smith and his appointment violates the appointments clause of the United States Constitution, saying Jack Smith's use of a permanent indefinite appropriation also violates the appropriations clause, but the court doesn't need to address that. The proper remedy for that funding violation, given that the dismissal is on the appointments clause grounds. The motion before the court challenges the legality of Jack Smith. So Trump submitted this. Two consequential aspects, both of which are matters of first impression. So first time we're actually hearing about any of this, and both of which must be resolved before this prosecution can continue. Now, the first is a challenge to Jack Smith's appointment under the appointments clause. We already know the appointments clause, Article 2, Section 2. It says a rule. If you're going to be an officer of the United States, whether you're an inferior or a principal officer, you have to be appointed by the president. Okay, it's in the Constitution. If you're going to be an officer of any kind, appointed by the president, confirmed by the Senate. Those are the rules. It then goes on to direct that Congress may by law vest the appointment of the inferior officers in the president alone, in the courts, or in the heads of the department, right? So the Constitution gives us a base layer rules, and they say Congress can change those rules, but it's very specific. They can only give it to the president, heads of departments, or the law. And for the purposes of this order, the court accepts that Jack Smith's contested view, right? Jack Smith says he's an inferior officer, not a principal one. So she's even giving him the benefit of the doubt here, which is wild. Now, although the court expresses reservations about that because it's obviously false. We're going to address those below. But even if we give him the benefit of the doubt and say he is an inferior officer, which he's not, then he still loses. The motion's second challenge is rooted in the appropriations clause, which is about money. And you can't get money unless you're appropriately appointed. So both of these appointments and appropriations challenges are framed in the motion. They raise the question. Here's the question, the big threshold question that's going to decide everything. Is there a statute? Is there a law in the United States Code that authorizes the appointment of a special counsel, Jack Smith, to conduct this prosecution? And it's about Jack Smith, again, who was never lawfully appointed or confirmed. After careful study of this seminal issue, Judge Cannon says the answer is no. Sorry, Jack, you lose. None of the statutes cited by the government as legal authority for the appointment gives the Attorney General broad inferior officer appointing power or gives Merrick Garland the right to appoint a federal officer with this kind of power, nor do special counsel's statutory arguments, appeals to inconsistent history, or reliance on out-of-circuit authority persuade otherwise. So Jack loses. The bottom line is this, says Judge Cannon. The Appointments Clause is a critical Constitution restriction and constitutional restriction stemming from the separation of powers, and it gives Congress a considered role in determining the propriety of vesting appointment power for inferior officers. The Constitution gives that power to Congress. Jack's position usurps that important legislative authority. The executive branch can appoint their own prosecutors and fund them indefinitely. They now transferred it to a head of a department, and in the process, they threaten the structural liberty inherent in the separation of powers. If the political branches wish to grant the Attorney General the power to appoint Jack Smith to investigate and prosecute this with the full powers of U.S. Attorney powers, then there is valid means to do so. All you have to do is appoint him. All you have to do is confirm him through the default method prescribed in the Constitution. Congress has already done that for tons of other U.S. attorneys. We saw it with Robert Hur. They can do it. Merrick Garland can do it. He knows how. Or Congress can authorize his appointment through enactment of a positive statutory law consistent with the Appointments Clause. So Congress then can pass a statute like they did with the Independent Counsel, which is no longer existing, but they did this before. So here's what Judge Cannon says in her order. It proceeds as follows. After laying forth the pertinent factual procedural background leading to the present motion, the court summarizes the legal principles underlying. The court then surveys the structure, and following all of that, we'll get to some more answers. And so let's take a look at the history. So on June 8th, 2023, we remember a grand jury came back with an indictment. Jack Smith signed it. Trump got charged with different charges, 31 counts of willful retention of national security information. Also charged two other people, Walt Nada and another gentleman. Now, on July 27th, the grand jury came back with a superseding indictment. There they added Carlos de Oliveira. On February 22nd, Trump filed this motion. We had a bunch of people file amicus briefs. Remember, Landmark Legal, constitutional lawyers, Ed Meese, many others. And the court later ordered supplemental briefing. Then we heard lengthy oral arguments just in June. Now, the motion seeks to dismiss the case. They say Jack Smith himself, Jack Smith specifically, was not nominated by Biden. He was not confirmed by the Senate, as would be required of a principal officer or an inferior officer. And Congress hasn't passed any laws to appoint him. And two, even accepting the position that he is inferior, none of the statutes cited vests Merrick Garland with the authority to appoint a special counsel with the full power to investigate and prosecute whatever they want. Jack Smith has that power. So you basically made him a U.S. attorney without actually making him a U.S. attorney. That's illegal. The motion separately raises a money challenge under the Appropriations Clause because he is drawing on a permanent, so they have a permanent indefinite appropriation that's reserved for independent counsel, which doesn't exist anymore. That doesn't apply to him. And so there is no other law authorizing the appropriation as to him. So they were stealing a bunch of money as well that was already earmarked for independent counsel. So our corrupt DOJ, which is supposed to be tasked with the duty of upholding the law and fairly interpreting the law, was stealing a bunch of money from the independent counsel bank account and then using an illegal prosecutor to go after their political opponent. The special counsel opposes both challenges. He says, as to appointment, he says, no, we are lawful. He cites the Nixon case. But as to the appropriations, he also says that he lawfully draws because from the indefinite appropriation, because he's like, I'm pretty much an independent counsel. He says, I still retain substantial independence from Merrick Garland, which again, it's logically inconsistent because if he still retains substantial independence, then that makes him a principal officer because he's independent. And he was appointed pursuant to the other law, right? They took all these other statutes and cobbled them together and said, well, we can kind of fit it in here. In any case, Jack Smith says all of these were lawful and he should have his money and his appointment. appointment. For some factual background, Judge Cannon walks us through how this all started. On November 18, 2022, Merrick Garland appointed John L. Smith, an attorney from outside the U.S. government. Jack Smith is not a U.S. attorney, to serve as special counsel for the Department of Justice. What's interesting is Jack Smith was not nominated by the president and he was not confirmed by the Senate. So in the order, Attorney General Garland, they said, the order states that Garland is, quote, vested, wherever that comes from, with appointment power. And he can do this. And how did they come up with this power? They said, well, Congress did pass some laws. 28 U.S. Code 509, 510, 15, and 33. Judge is going to walk us through all of these. But the appointments order then authorizes Jack Smith to conduct 2 investigations and to prosecute those crimes. The first, of course, is the J6 case. The second is the classified documents case. Now, with respect to the funding, Jack says that we can use this permanent fund to pay for our needs. This is a limitless appropriation. There's no end of it. It's just a slush fund for the DOJ. As of September 2023, Jack Smith has spent $12 million. Okay. So Trump has to defend this, right? This is the government. So they've used almost $13 million. And watch this. He's also dropped another $11 million in component expenses that are attributable to this investigation. So Jack Smith has dropped about $24 million on this prosecution. That's government money. That's our money. We paid for that. So our DOJ is using a slush fund that comes from our funds as taxpayers to prosecute a candidate in our election season. It's sick. Now, at the end of the appointment order from Merrick Garland, which was totally fake, there is the following reference to the Department of Justice regulations. So just to be clear on how this works, okay, we have, let's say the highest law in the land is here, okay, we'll call that the Constitution. Constitution says we got to do certain things. And in order to have someone like Jack Smith, we've got to have Congress pass some statutes. So we'll call this Congress, okay, so the Constitution's up at the top, then Congress is governed by the Constitution, and then Congress has the obligation and the power to create some law, right, some statutes. So then they will pass the statutes. And the statutes are what we referenced up here, U.S. Code Section 591. So we have the Constitution, you heard us talk about Article 2, Article 3, Article 1, Section whatever. Okay, these are all, the Constitution says Congress operates this way. Those are the rules for Congress. Then Congress passes the statutes. And then even below that, once we have the statutes, then we have what are called the regulations. So then we go down and we see the statutes will need interpretation because Congress is just filled with idiots. And so they write really bad statutes. So then the different agencies create regulations. And you probably have heard of these, the Code of Federal Regulations, often referenced as CFR. So you hear U.S. Code all the time, U.S. Code, USC. The CFR is the Code of Federal Regulations. So then they have regulations, and these regulations are often written by the agencies, which are interpreting the statutes. So you see how you can have this little game of telephone where things get perverted in the process. So the regulations then, right? So then the DOJ takes these statutes, which don't give them any power at all, and they write regulations that do give them power. So then those regulations are referred to Jack's regulations. They're enforced today, and they stem from a rule from Janet Reno in 1999. The notice of the final rule states that the regulations, okay, so the regulations replace the procedures for the statute. So Congress had a statute right here for independent counsel, and that authorized the independent counsel would have gotten. But then Congress realized that this was a really bad law. So they deleted this. And so there really was no statute anymore. And so what they did at the DOJ is they said, well, there really is no statute, but we really want that stuff. So they just wrote new regulations. They just wrote a whole new set of regulations, and they call them the Reno regulations. It consists of 10 sections spanning various topics ranging from a bunch of different things, okay? So you've got jurisdiction, power, staffing, conduct, accountability, a bunch of other things. And they call it 28 Code of Federal Regulations 600.1 to 600.10. Now, as most relevant here and more fully explored below, the Special Counsel regulations just created, okay, it's not Congress who did it. Congress didn't write these regulations at all. Congress got rid of the statute, and so they just made up their regulations. And here's what they gave themselves the power to do. Declare the grounds for appointing special counsel from outside the government. Just made that up. It's not in the law. There's no congressional law for that. Directed the Attorney General to establish the special jurisdiction of the special counsel. Authorized the special counsel to investigate and prosecute whatever the hell they want. And you see, every one of these is referencing the 600.6. That's the CFR. That's the Code of Federal Regulations. Also, that the Attorney General can remove the special counsel. The special counsel has discretion to consult with the Attorney General. All of these things, they just made up out of whole cloth. There's no basis for it at all. Now, distilled down for present purposes, Judge Cannon says, look, the special counsel regulations mandate that the special counsel be selected from outside outside the department, and then they empower that outside attorney to exercise all investigative and prosecutorial functions of a U.S. attorney. It's like, wow, okay, so they can just bring in their own special people to do what a U.S. attorney does, but we have rules on how we get U.S. attorneys. And Congress didn't give you any of these powers at all. Now, prior to the promulgation of these special counsel regulations, from 1978 through 1999, there was a statute, right? I explained that before. That statute is now expired. And we used to have a 3-judge panel. We used to have an independent counsel. And there was a big case about this. The legality of the independent counsel was brought up in a Supreme Court case in 1988, talking about the appointments clause and other things. Now, Congress let the Independent Counsel Act expire, never reauthorized it. But Janet Reno opposed the reauthorization, and she criticized the act. And so she then created her own. So the special counsel regulations have remained in place without change ever since. No such special counsel exists today like an independent counsel at all. And no such statute existed in November when Merrick Garland appointed Jack Smith. So let's talk about how this works. Article 2, Section 2, Clause 2 of the Constitution says that the president shall have the power by the advice and the consent of the Senate to make treaties. And the president shall appoint all other officers of the United States whose appointments are not already provided for and which shall be established by law. So the president can appoint the officers if the Constitution declares it or if Congress passes the law. But Congress may also, by law, which is by statute, meaning would have to pass a U.S. code, they may vest the appointment of those inferior officers as they think proper in the president alone or in the courts or in the heads of the departments. Very clear rules. Tells us how it works. Now, the appointment clause establishes 2 types of officers, principal or inferior officers. Principal officers must come with the advice and the consent of the Senate. The mechanism is the default manner of appointment, but we can also do other things. The clause says that Congress, by law, may, as it thinks proper, vest the appointment of the inferior officers, okay, so not the principals, in 3 places and only 3 places. President can vest, courts can vest, or the heads of the department can vest. So for our purposes, that would be like Merrick Garland. But any decision to dispense with the presidential appointment is Congress's to make, not the president's. And the president can't delegate that down to Merrick Garland, who then can appoint Jack Smith. They considered and initially maintained a proposal where the president alone would have had the authority to appoint officers. But it was replaced in 1787 because they wanted to increase the scope of that power. Now, the appointments clause is more than a matter of etiquette or protocol, okay? It is among the most significant structural safeguards in the constitutional scheme because we don't want the president to just appoint his own people because that's what the king had in England. And we were very sick of that because the bureaucracy just got bloated. We want some other checks and balances in this. It's rooted in the separation of powers. It's fundamental to our system of government. We do not want one branch of government like Joe Biden's aggrandizing itself at the expense of another. The appointments clause also preserves the Constitution and the structure of the Constitution. But if we put this another way, there can be no expansion of the vesting power beyond what is permitted in the clause. Just because Janet Reno created some regulations doesn't mean you can usurp this power. It must be strictly construed. Here's what we have learned so far, says Judge Cannon. The appointments clause reflects a carefully crafted system. Separation of powers and the executive and the legislative branches jointly participate in the appointments, and each side limits each other. That way we have public accountability, and the executive branch can't appoint their own prosecutors to prosecute their political opponents. Congress retains a pivotal role in the appointment sphere, a role that cannot be usurped or expanded, which they've done here by trying to take it away from them and give it back to the Attorney General. And the appointments clause imposes a mandatory and exclusive procedure that must be enforced according to its plain meaning without exception. Now, we need a clear statement rule. Trump appears to agree with these arguments that there needs to be a delineation of who is doing what, where they came from, talking about Jack Smith. And so as we continue, we'll fast forward through some of this clear statement stuff. Let's see how Jack Smith was appointed. Now, before delving into particular statutes, because the DOJ and Jack Smith say that they can cobble all of these various statutes together and then they can take their power from that. Before we do that, though, says the judge, the court wants to survey the structure of the DOJ. Why do they think that they're authorized to appoint people like this? Jack Smith, well, the DOJ operates under Title 28. In Chapter 31, Congress requires the president to appoint with the advice and consent of the Senate, the AG. Congress then provides the president to appoint various officers, all of which are expressly by and with the advice and consent of the Senate. That's the AG too. The deputy AG gets appointed with advice and consent. So does the associate AG. So does the Solicitor General. And the 11 assistant AGs do too. And each of these statutes statutes, Congress employs language tracking the default manner of appointing principal officers. It's the same. By contrast, in a separate section, Congress also permits the Attorney General to appoint non-officer employees to the agency. We also know about the FBI, right? The FBI is headed by a director, also appointed by the president. Chapter 35, which they reference, talks about U.S. attorneys, directs the president, again, to appoint by and with advice and consent of the Senate a U.S. attorney. So we have advice and consent repeatedly. All 93 U.S. attorneys currently have been appointed and confirmed this way. Now, interim U.S. attorneys can have specific restrictions on them, but they can be permitted without appointment by the president and confirmation by the Senate, but they're interim, limited duration, and so on. Now, it also bears noting that U.S. Code 54328 says allows the Attorney General to appoint attorneys to assist U.S. attorneys when public interest so requires, including the appointment of tribal prosecutors. And he disavows any notion that he is assisting a U.S. attorney. So Jack Smith is not relying on that. Now, there is one last piece, says Cannon, where there is some appointment authority. It's in Title 18, which is talking about prisons. So that doesn't apply here. So she says, all right, now let's talk about what they do have authority to do. Cannon tells us, all right, Jack Smith has 4 reasons why he says he can be on this case. But the court concludes that after reviewing all 4 of them, 509, 10, 15, and 33, that none of them give Jack Smith any power to do this. He is replacing the role of a U.S. attorney within his jurisdiction. He is not assisting a U.S. attorney. He is the U.S. attorney, and he's not allowed to do that. It's analysis. And the judge says, here's how I'm going to read this stuff, okay? I'm just going to read it according to its ordinary meaning, and I'm going to read it in context. I want to see what chapter it's in, because is this about prisons? Is this about the FBI? What is this about? I have to put it in context. And says, let's do it. So when we talk about U.S. Code 509, here's what Jack Smith says. He says, well, I have power under 509. But she says, no, you don't. It's a generic provision. All it talks about is functions of the Attorney General. That's all. Now, Jack Smith doesn't say that 509 creates an office, which he would need, nor that it grants any officer appointing power to the AG. In fact, it doesn't do any of those things. It's a general statute simply declaring that the Attorney General does things. No more discussion about this section is even needed. It's basic. It says all functions of the DOJ go to the AG, and it includes these things. Nothing in this law, which is U.S. code, okay, this is not a regulation. This is something Congress passed with the power of the Constitution behind them. Nothing in it says anything about a special counsel or Jack Smith. So they turn now then to 510, and they say, okay, well, we have also power under 510. No, you don't. This is also a general provision. It says the AG may from time to time make such provisions as he considers appropriate, authorizing the performance by any other officer or employer or agency of the DOJ, right? So she puts that in italics. So they have to actually work there. Now, Jack Smith does not classify or rely on this as officer appointing or office creating, because it doesn't. Does this create an office for you? No. Did this appoint you? No. So it uses similarly general phrasing as the previous section, and it says that you can do this for existing DOJ officers, not people who are outside the government. Jack, as all agree, and as required, was selected from outside the U.S. government. So we don't need to talk about 510. You have no power there either, Jack. How about the next one, 515? The third statute cited by Jack is fully quoted. 28 U.S. Code 515 says the Attorney General or any other officer of the DOJ or any attorney specially appointed when directed by the AG conduct any kind of legal proceeding which U.S. attorneys are authorized by law to conduct, whether she's a resident of the district or not. So Jack Smith says, oh, that looks pretty good. So I can kind of do whatever I want. Now, although Jack Smith relies on this section, Section B, the court will analyze both just to make sure. They say Section 515A, this is Judge Cannon, does not authorize the creation of any office. It doesn't say there's a special counsel office. It doesn't say that in here. And it does not authorize the Attorney General to appoint anyone. It says nothing about that. It says what people who are already a part can do. Nor does the special counsel meaningfully argue that it does. He doesn't even reference this in 515. As the text indicates, 515 just simply declares the AG says that any officer of the DOJ are authorized to conduct legal proceedings. So that's pretty obvious. And we can't infer that Jack Smith draws powers from that because it doesn't say that. So then Jack Smith turns over to 515B. He devotes a lot more attention to that one. Now, according to Jack, he says that B gives the AG authority to appoint special attorneys, which are kind of like a special counsel. He says this is so because he says it says specially retained under the authority of the DOJ. He says that phrase necessarily means retained by the AG. And so that we can be commissioned and we can be specially retained, that effectively means appoint. Okay, so going back to the subsection, special assistant and specially retained, he's saying that's kind of like special counsel. So it's kind of close. Each attorney that is specially retained, it's like a special counsel kind of, and it's like a special assistant. So he's like, oh, so that kind of gives me the power to do this. Cannon says, these arguments cannot be squared with the text, the context, or the history. It doesn't mean what you think it means. Section 515B, if you just read it plainly, is a logistics-oriented statute that gives technical and procedural content to the position of already retained special attorneys or special assistants. It specifies that those attorneys, again, already retained in the past sense, shall be commissioned. They're already part of the team. Now they're designated, they're entrusted, they're done to assist or as part of a commission. Now, Section 515B then provides that those already retained special attorneys must take an oath, and then it directs the Attorney General to fix their annual salary. Nowhere in the law does it give the AG any independent power to appoint officers like Counsel Smith, or anyone else for that matter. So it's just people who are retained. Now, this understanding as a descriptive statute about already retained attorneys is confirmed by additional features in the text. Other courts have already looked at this stuff, and they look at the word retain. It doesn't give anyone power to get anyone new. It says if they're already retained, ED, so it's past tense. And second, absent from Section 515B is a reference to any verb that allows an appointment at all. That's an active verb. So to justify that void, we don't have power to do anything. So to justify that, so Jack Smith realized that, he says, well, you just have to read it differently. So just read the terms specially retained ED and commissioned ED, past tense, as the functional equivalent of appoint. Well, it means they kind of were appointed, right? He says, no, the court is not going to do that. This is linguistic distortion, nor is it aware of any other vesting statute that uses those verbs as replacement for the verb appoint. When they mean appoint, they mean appoint. They don't mean commissioned or specially retained. For starters, the term appoint on the one hand and the terms retain or commission are not even interchangeable. Totally different words. She looked it up in Merriam-Webster's. Retain is different. Commission, right? She went through it's not the same word. We're not going to say the same. Also, Black's Law Dictionary says they're very different words. In any case, even if we do agree that there is some overlap, it remains the case that the Supreme Court has been apprehensive to accept other statutory terms as any stand-ins for the words appoint. The word appoint is a pretty big word in our Constitution, and so we don't just allow it to be watered down. And so if we look at the ordinary meanings of the terms, what does specially retained mean? Or what does commissioned as a special attorney mean? Well, retained means hired, employed. Commissioned means designated, classified. Together, those are fairly mundane. Those are already hired attorneys within the DOJ. They just become classified as special assistants. They take an oath, they get a fixed salary. That's all. That's all we can extract. There's no power to appoint anybody in there. Nor, as special counsel suggests, does the historical pedigree of presidential commission support this. And if we zoom out on this even further, the broader context of Title 28 and the use of the term special attorney within it also refutes Jack. He reads this wrong. It's an axiom of statutory interpretation that identical words used in different parts of the same act are intended to have the same meaning. Section 515 was enacted as part of a wide-scale government reorganization. There are other references to special attorneys talking about Section 519, but the term special attorney has known meaning in Title 28 that corresponds with other terms. And again, special attorneys assist U.S. attorneys. They're not special counsels. Special attorney is like an assistant to help a U.S. attorney. A special counsel is not. This leaves Jack Smith with a problem. Now he's got to figure out how to make special counsel match special attorney. The term special attorney is used in a bunch of different contexts, all meaning the same thing, someone who helps a U.S. attorney. None of the statutes make those match. And there's no basis to believe that Congress, when it designated categories, intended to create an overlap there. So zooming out, if we don't look at those statutes, Congress has repeatedly demonstrated its ability to imbue the Attorney General with appointment power. So they know how to do this too. Congress, for example, authorized the Attorney General to appoint an interim U.S. attorney when offices are vacant, so they know how to do that. Congress authorized the AG to appoint one or more assistant U.S. attorneys, so they know how to do that. They also know how to appoint other heads: education, agriculture, transportation, health and human services. So it's not like Congress was just wrong here or like made a mistake. They know how to make appointments. They know what they were writing. And Jack Smith, you're trying to change the words. The words are clear. The special counsel has no response to this. There's a clear pattern of congressional appointment language. They've been doing it for a long time now. But statutory context cannot be discounted, nor can clear statutory patterns. And so simply put, Jack's strained inferences about Section 515 do not make sense when viewed against Congress. So when Jack goes and reads the actual language, right? So he reads it, he says, oh crap, this statute sucks for me. The special counsel makes a series of unconvincing historical arguments. He's like, well, Jack says, Congress tacitly authorized this. So because we've been doing it for so long and nobody stopped us, we're allowed to do it. Upon review of the historical record Judge Alina calls murky, the court determines that whatever themes can be drawn from that historical murky background, they cannot supplant the plain language. But they tell us how the law came into being. In 1930, Congress added the term special attorney. Congress made some non-substantive changes to the wording. But Jack Smith says, all these amendments and Congress's failure to object to the use of special attorneys in the intervening years suggest Congress ratified this. Congress never questioned the power, so they're allowed to do that. And so the court thus returns to where it started. The Appointments Clause is among the most significant structural safeguards of the constitutional scheme. So too is appropriations, which carefully separates congressional control of the purse from the executive control of the sword. The consequences of relaxing either of these critical provisions are serious, both in this case and beyond. As Justice Frankfurter explained in his opinion in Youngstown, the accretion of dangerous power does not come in a day. It does come, however slowly, from the generative forces of unchecked disregard of the restrictions that fence in even the most disinterested assertion of authority. Illegitimate and unconstitutional practices get their first footing by silent approaches and slight deviations from legal modes of procedure. And so, for the reasons set forth, Judge Cannon, in conclusion, absolute bomb on Jack Smith. It is hereby ordered and adjudged that Trump's motion to dismiss the superseding indictment based on Jack Smith's unlawful appointment and unlawful funding is hereby granted. The indictment is dismissed. This order is only limited to this proceeding, and this order doesn't weaken any of the protections for the classified docs, but the clerk in Florida is directed to close this case. Any scheduled hearings are canceled. Any pending motions are denied as moot. Any pending deadlines are terminated. In chambers by our friend, Judge Alina Cannon. Amazing filing, one of the most meticulous decisions you've ever seen. So an absolutely amazing day, and we're glad to see this decision came down the way that it did.